A real estate broker or real estate agent is a person who acts as an intermediary between sellers and buyers of real estate, real property, and attempts to find sellers who wish to sell and buyers who wish to buy. In the United States, the relationship was originally established by reference to the English common law of agency, with the broker having a fiduciary relationship with his clients. A real estate broker typically receives a payment called a commission for successfully matching a seller's real estate with a buyer such that a sale can be made. This commission can be divided up with other participating real estate brokers or agents when applicable. An estate agent, being used as a term in the United Kingdom, means a person or organization whose business is to market real estate on behalf of clients. But there are significant differences between the actions and liabilities of brokers and estate agents in each country. Beyond the United States, other countries take markedly different approaches to the marketing and selling of real property. In the United States, however, real estate brokers and their salespersons assist sellers in marketing their property and selling it for the highest possible price under the best terms. Crucially, in the U.S., each state has their own laws defining the types of relationships that can exist between clients and real estate professionals, and those relationships, such as brokerage and agency, can vary markedly. Buyer's agent. When acting as a buyer's agent with a signed agreement, they assist buyers by helping him purchase property for the lowest possible price under the best terms. The real estate broker is obligated to provide fiduciary duties to whomever that broker services as a client. Dual agent. If the broker is helping both the buyer and the seller, this is referred to as a dual agency. Traditionally, the broker represents the seller, and his fiduciary duty is to the seller. If the broker suggests to the buyer that he will help the buyer negotiate the best price, the broker is practicing undisclosed dual agency, which is unethical and illegal in all states. Under a dual agency transaction, it is vital that the broker disclose to both parties whom he represents as a client and whom he represents as a customer. A real estate broker owes his client fiduciary duties, which include confidentiality, loyalty, obedience, accounting, and disclosure, to protect his license to practice. A real estate broker owes his customer fair and honest dealing and must request that both parties sign a dual agency agreement. Licensing. In most jurisdictions in the United States, a person must have a license before they may receive remuneration for services rendered as a real estate broker. Unlicensed activity is illegal, but buyers and sellers acting as principals in the sale or purchase of real estate are usually not required to be licensed. In some states, lawyers are authorized to handle real estate sales for compensation without being licensed as brokers or agents. The difference between salespersons and brokers. Before the multiple listing service was introduced in 1967, when brokers only represented sellers, the term real estate salesperson may have been more appropriate than it is today, given the various ways that brokers and licensees now help buyers through the process rather than merely selling them a property. Legally, however, the term salesperson is still used in many states to describe a real estate licensee. Real estate education. To become licensed, most states require that an applicant take a minimum number of classroom hours before taking the state licensing exam. Such education is often provided by real estate firms or by education companies, either of which are typically licensed to teach such courses within their respective states. The courses are designed to prepare the new licensee primarily for the legal aspects of the practice of real estate and to pass the state licensing exam. Once licensed, the licensee in most states is initially designated a salesperson and must work under a broker's license. Some other states have recently eliminated the salesperson's license, and instead all licensees in those states automatically earn their broker's license. A salesperson must place their license under a managing broker. Typically, there may be multiple licensees holding broker's licenses within a firm, but only one broker or the firm itself, the managing or principal broker, and that individual or firm is then legally responsible for all licenses held under their license. The term agent is not to be confused with salesperson or broker. An agent is simply a licensee that has entered into an agent relationship with a client. A broker can also be an agent for a client. It is commonly the firm that has the actual legal relationship with the client through one of their sales staff, be they salespersons or brokers. In all states, the real estate licensee must disclose to prospective buyers and sellers the nature of their relationship within the transaction and with the parties. See below for a broker, licensee relationship to sellers and their relationship to buyers. Real estate salesperson. When a person first becomes licensed to become a real estate agent, they obtain a real estate salesperson's license from the state in which he will practice. To obtain a real estate license, the candidate must take specific coursework and pass a state exam on real estate law and practice. To work, salespersons must be associated with a real estate broker. In Delaware, for example, the licensing course requires the candidate to take 99 classroom hours in order to qualify to sit for the state and national examination. In each successive year thereafter, the license holder must participate in continuing education in order to remain abreast of state and national changes. Many states also have reciprocal agreements with other states, allowing a licensed individual from a qualified state to take the second state's exam without completing the course requirements or, in some cases, take only a state law exam. Real estate broker. After gaining some years of experience in real estate sales, a salesperson may decide to become licensed as a real estate broker in order to own, manage, or operate their own brokerage. In addition, some states allow college graduates to apply for a broker's license without years of experience. College graduates fall into this category once they have completed the state-required courses as well. California allows licensed attorneys to become brokers upon passing the broker exam without having to take the requisite courses required of an agent. Commonly, more coursework and a broker state exam on real estate law must be passed. Upon obtaining a broker's license, a real estate agent may continue to work for another broker in a similar capacity as before, or take charge of his own brokerage and hire other salespersons licensees. Becoming a branch office manager may or may not require a broker's license. Some states allow licensed attorneys to become real estate brokers without taking any exam. In some states, there are no salespeople, as all licensees are brokers. In the United States, realtor is a registered trademark of the National Association of Realtors. There are 1.3 million realtors, mostly in the United States, and an additional 1 million licensed real estate agents who are not members of NAR and cannot use the trademark title of realtor. However, the U.S. Bureau of Labor Statistics claims only about 600,000 working brokers, salespersons. In Canada, realtor is a registered trademark of the Canadian Real Estate Association. Agency relationships with clients versus non-agency relationships with customers. Relationship. Conventionally, the broker provides a conventional full-service, commission-based brokerage relationship under a signed listing agreement with the seller or a buyer representation agreement with the buyer, thus creating under common law in most states an agency relationship with fiduciary obligations. The seller or buyer is then a client of the broker. Some states also have statutes that define and control the nature of the representation. Agency relationships in residential real estate transactions involve the legal representation by a real estate broker of the principal, whether that person is a buyer or a seller. The broker and his licensed real estate salespersons then become the agents of the principal. Non-agency relationship, where no written agreement or fiduciary relationship exists. A real estate broker and his sales staff work with a principal who is known as the broker's customer. When a buyer who has not entered into a buyer agency agreement with the broker buys a property, that broker functions as the sub-agent of the seller's broker. When a seller chooses to work with a transaction broker, there is no agency relationship created. Transaction brokers state real estate commissions, notably Florida's after 1992 and Colorado's after 1994, created the option of having no agency or fiduciary relationship between brokers and sellers or buyers. Having no more than a facilitator relationship, transaction brokers assist buyers, sellers, or both during the transaction without representing the interest of either party, who may then be regarded as customers. As noted by the South Broward Board of Realtors, Inc., in a letter to State of Florida legislative committees, the transaction broker crafts a transaction by bringing a willing buyer and a willing seller together and assists with the closing of details. The transaction broker is not a fiduciary of any party, but must abide by law as well as professional and ethical standards. The result was that in 2003, Florida created a system where the default brokerage relationship had all licensees operating as transaction brokers, unless a single agent or no brokerage relationship is established in writing with the customer, and the statute required written disclosure of the transaction brokerage relationship to the buyer or seller customer only through July 1, 2008. In the case of both Florida and Colorado, dual agency and sub-agency no longer exist. Designated agency. The most recent development in the practice of real estate is designated agency, which was created to permit individual licensees within the same firm, designated by the principal broker, to act as agents for individual buyers and sellers within the same transaction. In theory, therefore, two agents within the same firm act in strict fiduciary roles for their respective clients. Some states have adopted this practice into their state laws, and others have decided this function is inherently problematic, just as was dual agency. The practice was invented and promoted by larger firms to make it possible in theory to handle the entire transaction in-house without creating the conflict of interest within the firm. Dual or limited agency. Dual agency occurs when the same brokerage represents both the seller and the buyer under written agreements. Individual state laws vary and interpret dual agency rather differently. Many states no longer allow dual agency. Instead, transaction brokerage provides the buyer and seller with a limited form of representation but without any fiduciary obligations. Buyers and sellers are generally advised to consult a licensed real estate professional for a written definition of an individual state's laws of agency, and many states require written disclosures to be signed by all parties outlining the duties and obligations. If state law allows for the same agent to represent both the buyer and the seller in a single transaction, the brokerage agent is typically considered to be a dual agent. Special rules often apply to dual agents, especially in negotiating price. In some states, dual agency can be practiced in situations where the same brokerage represent both the buyer and the seller. If one agent from the brokerage has a home listed and another agent from that brokerage has a buyer-brokerage agreement with the buyer who wishes to buy the listed property, dual agency occurs by allowing each agent to be designated as an intra-company agent. Only the broker himself is the dual agent. Some states do allow a broker and one agent to represent both sides of the transaction as dual agents. In those situations, conflict of interest is more likely to occur, typically resulting in the loss of advocacy for both parties. Types of services that a broker can provide. Since each province's and state's laws may differ, it is generally advised that prospective sellers or buyers consult a licensed real estate professional. Some examples: comparative market analysis, an estimate of the home's value compared with others. This differs from an appraisal in that property currently for sale may be taken into consideration. Total market overview, an objective method for determining a home's value, where a CMA is subjective. Broker's price opinion, estimate of a property's value or potential selling price. Real estate appraisal, in most states, only if the broker is also licensed as an appraiser. Exposure, marketing the real property to prospective buyers. Facilitating a purchase, guiding a buyer through the process. Facilitating a sale, guiding a seller through the selling process. FSBO document preparation, preparing necessary paperwork for sale by owner, sellers. Home selling kits, guides advising how to market and sell a property. Hourly consulting for a fee, based on the client's needs. Leasing for a fee or percentage of the gross lease value. Property management, exchanging property, auctioning property. Preparing contracts and leases. These services are also changing as a variety of real estate trends transform the industry.